specializations for semiconductor layouts. So we are actively having trademark applications, approximately 15,000 applications presently active in our portfolio, and patent applications around 1,500 applications active, and we have 125, close to 125 actually grants in 2023, patent grants in India. Typically, I'm a backbencher actually from school, so thinking of lot of things out of box, sitting in classroom as well. So it all started when I actually modified my bicycle. It's a old bicycle actually given by my father actually, and then I tried to tweak a bit for different applications, like for holding a. I mean, we do have carriages for actually sticking our bag, but school bags are a bit heavy, and we have a lunch box, so that I need something like I can hang, or maybe um, make the bag and the my lunch box actually sit, not to carry on my shoulders. So from there, it's something like it's when I'm 8 9 years actually. So somehow I'm not a person want to excel in a particular field. Luckily, I'm today actually I'm a patent attorney, IPR consultant for many startups, but I'm not that person initially. So I'm like a jack of all, rather actually master in one. But still, that background, after my bachelor's in engineering, in mechanical engineering, I started working with a design company, all know like Infotech Enterprises in Hyderabad. So I was 2 years into design, design associate, but not happy. Again, actually, I thought of actually pursuing further my studies. I went to Germany for actually doing my master's in mechatronics. So after that, actually, after the course, I joined a company in Germany as an quality engineer. It's a automobile components manufacturer. So again, an year of job there. Actually, I'm not happy. I'm still pursuing. I want to pursue something else. So I took an um, actually I thought of actually doing a PhD in material science. I started it, but somehow there are other reasons I have to come back, not continuing that. So I was in India. So at that point in time, actually, I started with learning something on my own. I want to start something, and was into manufacturing for some days, into material science field, manufacturing of ferroalloys. I was part of an organization. So then actually I thought like I pursue law along with my other activities. So started doing LLB. So learned patent law. With the previous experiences, I actually correlated my knowledge to actually excel in this IP law. Started this company in 2012, and since then actually slowly but steadily, we are happy. Like I'm happy myself doing this thing for almost 10 plus years now. గుడ్. పేటెంట్ అంటే ఇట్స్ తెలుగులోనే మాట్లాడదాం. సో పేటెంట్ ఒక ఫార్మ్ ఆఫ్ ప్రొటెక్షన్ ఫర్ ఇంటలెక్చువల్స్ కి. అంటే ఇంటలెక్చువల్ అంటే ఎవరికైనా ఒక ఐడియా ఉండొచ్చు, ఏదైనా చిన్న ప్రాబ్లమ్ సొల్యూషన్ గా ఆయన ఒక చిన్న డివైస్ కానీ లేదంటే ఒక సొల్యూషన్ కనిపెడితే దానికి వచ్చే రైట్ ని మనం పేటెంట్ రైట్ అంటాము. బట్ దేన్నైనా మనం పేటెంట్ రైట్ అంటాం జనరల్ గా. సో పీపుల్ generalize all the IP rights as patent rights, but patent is for any technical thing, for an object or maybe for an article which is made newly and which has an improvement when compared with existing products. So patent is a statutory right for an inventive for an invention actually given to an inventor for 20 years of time. So in India as well in other countries. So it has a certain procedure actually. There is a criteria of mm, eligibility and availability, we can say, but it's not availability. Like the patent office after application filing, they'll see whether it is new or not and whether it is useful or not. And then they have further questions like they go into even asking the inventor to show the prototype or maybe the product. It can be a sample or a small prototype also, but they'll ask us that they may ask us for actually a proof of concept as well. Good question, Raj. Actually, there is something like this notion. If you get a patent, it is forever, or maybe it is for whole of the world. It's not like that actually. If we have an invention as per the laws of the state, that means like we are as we are in India, for example. So we have to file it in India, or if we are not interested in filing in India, we can file it in other countries as well by just notifying the Indian Patent Office that we are not interested here, but we are pursuing it somewhere else. But an application need to be made first in one country. That application will become our home country application, irrespective of our nationality. And from there, like we can take priority and actually we can file our other applications. Means the same application we need to file in other countries wherever we are interested in. So the term of every patent granted is 20 years, and the term is actually calculated from date of filing. So from date of filing, if it is granted, it will be granted for 20 years, but provided actually we have to renew it, we have to maintain it. So in India, for example, from third year, before starting of third year, so it is considered for third year. So we have to pay the renewal fee. It is 800 rupees for a natural person as an applicant. So it is 800 rupees in third year till sixth year, and again from seventh year it changes 2,400 per year from seventh year. Likewise, we have this renewal fee need to be paid for whole of the 20 years to have it active. You'll get a grant, but once it is granted, to actually to have it active, and if you want to enforce it on someone else, for example, someone is actually using the same thing without actually taking a license from us. In that case, like if you want to enforce our right, so the right need to be active. So it is not that like we have a grant and we left it after the grant, it is not active and we want to enforce our right, it is not possible. So it's actually Patent Act 1970. So it is the base of Indian patent system. So thereafter, like there are so that actually patent office wants to reduce it to 30 months now. So that is the proposed amendment in rules. So Act actually defines what can be filed, what cannot be filed, and what are all the rights of the patentee after grant, or maybe what are the powers of the patent office or the controllers. All these things are actually defined in Patent Act, and rules are related to the fee structure, the timelines. So these will be actually framed as rules. So there we have amended rules. The important amendment of rules is in 2016, which actually facilitated early examination for women applicants, early examination for startups, early examination for MSMEs. So that is it's a boost for Indian patent system. Like 2016 amendments are the boost for Indian patent system, and thereafter actually they are very proactive in amending rules in actually leaving out old fashioned aspects like submission of the hard copies every time, uh, things actually been actually avoided. So Act actually, we have 1970 Act. It is 39th of 1970, 39 of 1970, enacted in all the definitions you can simply say. So what to file, what not to file, who can file, what if it is granted, what if it is opposed, what if otherwise. All these things are actually defined in the Act. If we have a grant everywhere, I mean, for example, Indian laws cannot actually protect us or maybe give protection in other countries the same way US laws cannot give protection in India. Though we will have actually some sharing of information or maybe some acts or maybe some treaties between countries, like Japan and Indian patent system has a treaty. Like Indian applications are actually taken for early examination in Japan, as well vice versa in India. So like that, like we will have treaties, but otherwise Indian patent cannot be enforced in other countries. That means like Indian patent is not valid in other countries. If I have interest, yes, yes, yes. So yes, it's a costly thing actually, and the cheapest country or maybe easy way, not easy way, cost-effective patent grant system. We will, if you want to name a country, that is India, and the next will be, I mean, from sitting from India, next will be US. Um, but but there are certain group of countries formed as one patent office. For example, in Europe, like all the European countries, we have a single patent office, European patent office. So with one application, we can have a grant for all the countries there. And there are other two more groups, ARIPO, ARIPO, and one more Eurasian group actually. There also we have 17 countries in one group and again 19 countries in one group. So we can opt for those if someone is actually interested in filing in all the countries. I actually never saw even Facebook or maybe Google or Microsoft actually had a patent in all the countries. So it is, yeah, it's not that maybe it's not ideal or maybe viable or maybe required actually to get a grant in all the countries for some products or maybe almost all for all the products, maybe leaving out these um, Facebook or maybe the LinkedIn that we are talking. So even this actually major aspect of LinkedIn or with Facebook, uh, the portal or the interface that we use as users will actually come under Copyright Act. Not everything can be patented. They do have patents as well. So for example, this voice that we are recording and when it is not known, voice recording and maybe broadcasting over internet through their portal. This is one aspect. Like eBay actually first patented it, and even the Amazon or eBay that we know. So ebay.com actually, eBay Inc. Incorporated in USA. They had first patent on actually listing products on a web page. Listing products means like listing, sorting, or maybe filtering options. All these things actually they first actually came up with this thing. Nice. Hello, sir.
Hello, good evening. May I speak?
Yeah, please.
Yeah, so I am a artist also, and I have also written few articles slash poems. And what is a correct way, correct procedure to like have it copywritten? Art especially, like yeah, exactly. Like how do I do that? Like I have no
Yes.
knowledge on this topic. That's why I joined this.
Thanks for joining, Varshi. Actually, that's
Mm.
a relevant question. Actually, though we are actually discussing about the patent system and the basics of patent filing in India. So, copyright is also a form of IP. So, whatever we cannot actually file it as patents, like we will get copyrights. That is a general answer. But the artistic works, any artistic works, like including literature work or the art that you do, or a sound recording, like the voice that we are actually recording now, or the cinematographic works. That means like the videos. All these forms actually, apart from these four, like the computer programs, that is softwares. So these five things actually are eligible to file under copyright registration. So, but copyright registration doesn't mandate a registration. So if you can actually uh, publish it on your page, or maybe somewhere where you can actually show like a date of publication, etc., then it is yours. So that means like without publication also you can keep it for yourself. With publication you can actually claim your rights, or with a copyright registration you can definitely claim your rights. So the government fee in India is 500 rupees only for each art, but the conditions are actually you can only protect one title in one application. We can, I mean, for example, in art, for example, you made multiple arts, maybe the same character or maybe same scenario or same thought. You made it into maybe the continuation of it, or maybe as a play, like you have drawn many pictures. In that case actually you have to file it separately. You cannot file it as a book. But in literature work, for example, for a novel or maybe for a book, you can actually file, because it is one title, though it has chapters in it, but it is one title. You can file it as one application. But for arts actually, because each article or each item has one application, so that is the criteria in even patents, trademarks, or copyrights. So you have to file your multiple applications to, if you want to have a registration. But without registration also, it is like you are protected, because like Copyright Act doesn't mandates registration. And one more important thing is like when compared with trademarks or maybe patents or designs, copyright will have broader protection. Protection in the sense, it actually gives you a right with the registration. It gives you a right for lifetime of yours, and you can even transfer the right to someone else, for your descendants, or maybe some whoever it is. Like it's up to you. You can transfer the right easily, or you can actually license your right to publishers, or maybe uh, any other authors actually to use. So this is a broader aspect. Like actually, copyright will give you broader protection, copyright registration, and as I told, like it's lifetime. Yes.
Yeah, the thing is that in the past we've developed softwares and we took care of the patent and everything, but the thing with art is that it is frequent, right? So every time we create something, how do I you know protect it? Yeah, yeah, protect it instantly. Like that is the question I have. But besides that, it's all resorted. Yeah, yeah. It is actually named after my mother. She passed away, and her signature is like that, A and S. So we
Oh,
incorporated that into the logo.
that is excellent.
Uh, and I'm actually
Great way
I've
to
done,
remember her actually.
yeah.
It's a very good gesture and thought actually for she.
Like most of the poems I've written so far and paintings I've painted so far, I want to protect them instantly. Like as soon as I've done it, if there is any quick online procedure or anything, uh,
We
like
have actually, yes, 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 yes. All the songs that we actually listen to, apart from the original. I mean, apart from they are released as albums actually. So there are societies, corporate societies for actually publishing the work. As I told, like if you can publish your work, that itself is your proof, and you can actually claim your right. So for this purpose, there are societies, but yeah, we don't have any in India active, which are active actually. But we have these societies, international societies actually. So we can be a member of them, and we can submit a copy of it to them, and they'll publish on your behalf as a publisher for time being, and they'll give you a timestamp. For example, the publication and a certificate kind of thing, an email confirmation or something. So that's yes, yes. You can have your website, and you can actually mention the year of publication on each publication. You see on websites like they publish the year whenever they actually yeah, on the footer of the page, or maybe somewhere evident. I mean, it's only the year is enough, not required the date, but the timestamp you can actually get in multiple ways, like with the Wayback Machine on the domains also we have now. We- Yes, 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 yes. That is a proof actually. So Copyright Act only needs a proof that that the work belongs to us. Very good question, actually. Anything which is new, which is new, which has an improvement, and which is useful can be filed as a patent. But yes, there are again subject matters which cannot be patented. For example, like the works that we are actually talking, Varshi as an artist, the poems, or maybe the arts, or the sound recordings, because these are artistic nature, and why these are actually omitted from patenting is, so these are kind of works which may need improvement on a daily basis, or maybe which has to be there forever. For example, like a art, or maybe some works, for example, they need improvement every day. For example, we read newspapers, Inadu, or maybe the Hindu. The template of the newspaper of Hindu or the Inadu are fixed, but the content is not fixed, right? So it's obviously a daily newspaper. It has to be updated with daily news. So likewise, it's a very dynamic the dynamic nature of these works actually. I mean, the reason is that, like they are omitted from patents, but otherwise, so patents are for any articles. Precisely, patents are for articles, and that too articles, not for shapes. Again, there is another aspect for only shapes. We have design registrations. We can also call design patents, so we can also call design patents, but we won't call them as design patents in India. We call them as simple industrial design registrations in India. So for the aesthetic of any known product, for the aesthetic of any known product, for the watch that we are wearing, for the shirt or the trouser that we are wearing, anything like anything that we see or we use, all those things are actually of different brands in different shape, or different brands in different colors, or maybe in different patterns. So all these things are can be protected under design registrations for 10 years plus additional 5 years a corporate protection for them. So their life is 15 years. For other articles, like which has life, for example, which has utility, uh, these are actually can be patented, and the conditions are like the applicants need to show it is new, it is not obvious, and it has usage. And then again, actually, they won't fall into the the barred items. For example, ammunition, or maybe weapons, or the games like maybe um, uh, related to machines related to casino, or maybe cards playing or something like that, which are barred. Barred means like which are not allowed in this country at least. Maybe these are allowed in US. There you can actually patent them as well. So someone can actually patent a gun also there in US, but not in India. So there are certain restrictions on certain products. Those products cannot be patented, but otherwise, anything new and has usage, and which can be differentiated, or maybe the inventiveness or the improvement can be shown when compared with the existing. Those are all can be patented. Thank you, Raj, for hosting me. Thank you. Yeah, thank you, Varshi and Dr. Srinivas Garu.